Hello, this is R.J. Deacon reading the Supreme Court of the United States opinion syllabus in Lucky Brand Dungarees versus Marcel Fashions Group. Certiorari to the United States Court of Appeals for the Second Circuit. Argued January 13th, 2020. Decided May 14th, 2020. Petitioners, collectively Lucky Brand, and respondent, Marcel, both use the word lucky as part of their marks on jeans and other apparel. Marcel received a trademark registration for the phrase "Get Lucky," and Lucky Brand uses the registered trademark Lucky Brand and other marks with the word lucky. This has led to nearly 20 years of litigation, proceeding in 3 rounds. The first round resulted in a 2003 settlement agreement in which Lucky Brand agreed to stop using the phrase "Get Lucky," and Marcel agreed to release any claims regarding Lucky Brand's use of its own trademarks. In the second round, 2005 action, Lucky Brand sued Marcel and its licensee for violating its trademarks. Marcel filed several counterclaims, turning, as relevant here, on Lucky Brand's alleged continued use of Get Lucky, but it did not claim that Lucky Brand's use of its own marks alone infringed the Get Lucky mark. In both a motion to dismiss the counterclaims and an answer to them, Lucky Brand argued that the counterclaims were barred by the settlement agreement, but it did not invoke that defense later in the proceedings. The court, in the 2005 action, permanently enjoined Lucky Brand from copying or imitating Marcel's Get Lucky mark, and a jury found against Lucky Brand on Marcel's remaining counterclaims. In the third round, a 2011 action, Marcel sued Lucky Brand for continuing to infringe the Get Lucky mark, but it did not reprise its 2005 allegation about Lucky Brand's use of the Get Lucky phrase. After protracted litigation, Lucky Brand moved to dismiss, arguing for the first time since early in the 2005 action that Marcel had released its claims in the settlement agreement. Marcel counterclaimed that Lucky Brand could not invoke the release defense because it could have pursued that defense in the 2005 action, but did not. The district court granted Lucky Brand's motion to dismiss. The Second Circuit vacated and remanded, concluding that defense preclusion prohibited Lucky Brand from raising an unlitigated defense that it should have raised earlier. The Supreme Court held the decision below as reversed and remanded, and Justice Sotomayor delivered the opinion of the court. Because Marcel's 2011 action challenged different conduct and raised different claims from the 2005 action, Marcel cannot preclude Lucky Brand from raising new defenses. This case asked whether so-called defense preclusion is a valid application of res judicata, a term comprising the doctrine of issue preclusion, which precludes a party from relitigating an issue actually decided in a prior action and necessary to the judgment, and the doctrine of claim preclusion, which prevents parties from raising issues that could have been raised and decided in a prior action. Any preclusion or claim preclusion of defenses must at a minimum satisfy the structures of issue preclusion or claim preclusion. See Davis versus Brown. Here, issue preclusion does not apply, so the causes of action must share a common nucleus of operative facts for claim preclusion to apply. That's the restatement second of judgment, section 24, comment B on page 199. Because the two suits here involve different marks and different conduct occurring at different times, they did not share a common nucleus of operative facts. The 2005 claims depended on Lucky Brand's alleged use of Get Lucky, but in the 2011 action, Marcel alleged that the infringement was Lucky Brand's use of its other marks containing the word lucky, not any use of Get Lucky itself. The conduct in the 2011 action also occurred after the conclusion of the 2005 action, but claim preclusion generally does not bar claims that are predicated on events that postdate the filing of the initial complaint. That's Whole Women's Health versus Hellerstadt. Because events occurring after a plaintiff files suit often give rise to new operative facts, creating a new claim to relief. Marcel claims that treatises and this court's cases support a version of defense preclusion that extends to the facts of this case. but none of those authorities describe scenarios applicable here, and they are unlikely to stand for anything more than that traditional claim or issue preclusion principles may bar defenses raised in a subsequent suit, principles that do not bar Lucky Brand's release defense here. The decision below is reversed and remanded, and Justice Sotomayor delivered the opinion of a unanimous court. Thank you for listening. If you'd like to get a hold of us, we can be reached at rhodesscholar80@gmail.com. That's ROADS and the number 80, or on Twitter at Court Syllabus.